The Lagos State Governor, the senior advocate of Nigeria, has come out to say, at the legal year ceremony speech, he came out to say that, well, yes, we desire judicial autonomy. Yes, we're not opposed to the idea. But the problem is that we don't get our allocation and internally generated revenue wholesale. So how do we then, give the judiciary what it is due wholesale when we don't even have that allocation wholesale? This is one of the challenges that he sees, confronting judicial autonomy. What do you think of that?
I don't buy that, and I'll tell you why I don't buy that. There shouldn't be any bottleneck as to those are implementation. If we agree that the votes meant for the judiciary should be allocated for the judiciary, it then means that it is whenever you have it, then it goes to judiciary automatically. If, for example, at the National Assembly, the vote has been approved, it means that Mr. President has no business, or the officers of Mr. President has no business keeping such money. And that it should be disbursed once it has been approved, and the money is there. If the money isn't there, whenever the money becomes available, it should be disbursed. So those are implementation. But what we are talking about here is, one, the law says this. Will the occupant of that office, of the executive office, will he have the will to carry out or to effect what the law says? If you have the will, it means that even if the money isn't present at that time, whenever the money is present, then you disburse it. That is it. Also, you disburse it. Or as per whatever is available.
So you think it is possible, and it's just the problem of...
It is possible. It's just it is the implementation issue. And that implementation shouldn't stand as a barrier to complying with the provisions of the law.
Another issue I want to talk about.
I don't know if you followed the news that there was a large percentage of failure at the law school. What do you think is the quality of law graduates that the school is churning out, and how can we improve standards?
It's abysmal. It's poor and it's abysmal. And I want to even say that a lot of faculties that offers law, it's either they are not accredited, it's either the standard in the universities, particularly those private universities, it's either the standard in the university is so poor, is so abysmal, that the Council of Legal Education should and ought to up the ante. It is very, very crucial. We know that standard has fallen generally across board.
With our educational system.
With the educational system, even the legislature. Sometimes you look at what happened in the National Assembly and you just marvel. And because those are the people that are supposed to be a check on Mr. President, and you see the comportment, the courage, and some of them don't even have a clue. Meanwhile, the same Mr. President doesn't have a clue. It's standard has fallen generally across board. But the relevant body that is saddled with that responsibility is the Council of Legal Education. And the Council of Legal Education, I am also certain, is up to the task. And that is why they have been bold enough to say, if you fail, you fail. They might be hue and cry, but if you fail, you fail. At law, there's no passing up. You either know your law or you don't know your law. You either know your procedure or you don't know your procedure. You are either good, there's no middle course. Are you aware that at law school will grade you with your list? So you expect to be master in all the courses.
You talked about the National Assembly, so let me take you back to the National Assembly, specifically the House of Reps now. Last week, they voted to effect 71 amendments to some sections of the 1999 Constitution. One major one was an amendment that could impact on speedy delivery, because we always say justice delayed is justice denied. And they inserted an alteration into Section 241, which bars Nigerian courts and tribunals from staying any proceedings on account of an interlocutory appeal. What's your take on that?
It ought to have been done long before now. It's overdue. Are you aware that one of the major bottleneck to deliver in justice sector delivery and to speedy dispensation of justice is interlocutory appeals. And when we say interlocutory appeals, it means that even if the judge coughs, and you say, oh, he's coughed in a particular manner not known to law, and then you take it up. In an Amadi and NNPC, Justice Iwes lamented that it's taking a particular interlocutory appeal 13 years to get to Supreme Court. Interlocutory appeal. Sometimes, my view has been that sometimes it borders on professional misconduct. Particularly no area of law is by now is regarded as recondite. No area of law. Or let me say, very few. So, in other words, as a lawyer, you're expected to know. The court is expected to know. And then you waste the time of the court. You take it all the way. Because you are aware that the rules allows you. So now that it's been, well, I pray that the proposer meets with the consent of Mr. President and is ultimately passing to law. I pray, because it will accelerate justice. I know it, that it will accelerate justice. So that even when you disagree, allow the court to make a final pronouncement. Allow the Court of Appeal or the higher court to have a wholesome look rather than interlocutory look, and then for the case to be remitted back. And sometimes, are you aware that sometimes some of the witnesses will have died, sometimes the matter will have become statute bar, and then some injustice will have been wrought.
And it compounds and adds to the delay.
And it compounds and adds to the delay. And then you have a particular matter being dragged on for sometimes 7, 8, 9, 10 years in a particular court.
There's another major development was the removal of the immunity clause for the president, the vice president, governors, and their deputies. And so by implication, the occupiers of that offices cannot be tried for criminal offenses. Is that a good one too?
In Nigeria, we are being ruled by charlatans. And mark my word, very few of our so-called elected officials or office holders you can call people of character. People of character. And they come in, and the state protects them with the immunity clause. It's only in Nigeria that you find things like that.
So that argument that it will be a distraction, you don't buy it.
Detraction to what? To their looting. Detraction to what? To their incompetence. Detraction to what? To their ability to call white black or black white. Or detraction to what? Wherever there is no offense, wherever there is no yardstick, wherever there isn't any punishment, wherever there is no watchdog, then you have latitude. And you have laxity, and everybody just behave as they like. And that's what has happened in the past 10, 12 years in Nigeria. And even before then. And because Nigeria is nobody's business. In fact, laws in Nigeria are obeyed in disobedience. Laws in Nigeria are obeyed in disobedience. It's sad. And this is because Nigeria, we don't punish crime. We don't punish for crime. In fact, we celebrate criminals. So, removing the immunity clause is just one step towards ensuring good governance.
Staying with Constitution Review, the Senate last week Tuesday approved 23 out of the 71 amendment proposals recommended by both chambers of the National Assembly, bringing to an end a process that has taken about 3 years.
Chief of the proposed amendments adopted by the Senate was that of sections 174 and 211, which separates the office of the Attorney General of the Federation or Attorney General of the State from the office of the Minister of Justice or Commissioner for Justice. Sections 82 and 122 also reduce the period within which the President or Governor can authorize the withdrawal of money from the Consolidation Revenue Fund in the absence of an Appropriation Act from 6 to 3 months. The Senate, in addition, retained Section 308 of the 1999 Constitution, which confers immunity on the President, Vice President, Governors and Deputy Governors, in contrast to the House of Representatives' decision, which removed it. The Senate also upheld the full-fledged autonomy for the local government areas by providing for their funding, tenure, elections, and to clearly delineate their powers and responsibilities to ensure effective service delivery and insulate them from undue and counterproductive interference from state governors. The lawmakers also conferred the exclusive jurisdiction to try electoral offences on the Federal High Court, adding that a court or tribunal shall not stay proceedings on account of any interlocutory appeal. As constitutionally required, the two chambers, after the adoption of the report containing the 23 amendment provisions, resolved to quickly send the report to the State Houses of Assembly for the purposes of getting the concurrence of 2/3. This will give the amended items the force of law, since presidential assent for such an exercise is no longer needed, in line with the amended Section 9 of the Constitution. It remains to be seen if the State Houses of Assembly will concur with the National Assembly.
We'll keep an eye on that process and dissect it in the days ahead. But this is where we wrap up today's show. Do let's interact via email, Facebook, or Twitter. Don't forget that you can also watch these and past episodes of the program on our YouTube channel. I'm Shola Sheyeli. Thank you for watching.